Hey everyone. Good evening to those I didn't say hi yet. Make sure your cameras are on. On everyone, cameras. People already watching on YouTube. Whoever's watching, hi, let me know you're there, or if you have any questions, always welcome to participate. All right, we have a few questions here already. See what questions we have. All right, Mr. Badur, let's see. In escrow procedures, the buyer have the freedom to refuse the title without reason if they change their mind on the spot. I think with a little common sense, you answered yourself already. You think, what is escrow procedures, first of all? And do you think we can quit anything just because, without reason, just because? There's only one period of time where we can do that, and that's called the cooling off period. The cooling off period is from the moment you put an offer till the deadline of making that contract binding. So as an example, in the state of New Jersey, the cooling off period is 3 business days. Some other states can go up to 7 days, right? So the cooling off period is like the, hey, in case you change your mind, or do you want to review with an attorney? You can. So that's the only time you can walk away without reason. From there on, once we're under contract, until closing, there has to be a legal reason for you to walk away. Legal reasons would be you don't get approved for mortgage. Legal reasons would be there's an issue with the title, okay? Legal reasons would be the inspection was not satisfactory, so I checked the inspection report. There's way too much to fix or whatever, so no, I don't want it, right? These were surprises that showed up. That's a legal reason, because now you have evidence that allows you to walk away. These are considered legal reasons because they are contingencies. These are conditions to the closing. So that's the only time you can walk away, all right? So can you walk away without any reason? No. Do brokers add a clause or fee in a contract to avoid that from happening? So again, until we are binding, until it's under contract, people can walk away. If you've done your job, let's say you represent the seller, if you've done your job and the seller walks away for no reason, you as a representative of the seller might be entitled to some compensation. Okay, and that compensation will be the money that you've spent on it, for instance. Maybe if you're all the way at the end, you're like at closing and they decide to back out, now you can go after commission. But until the cooling off period ends, or that 3 business days ends, for instance, in New Jersey, right? Until that happens, then they can walk away at any time from the deal. But they still have the obligation of the listing with you. Therefore, they might be liable to, again, pay for marketing or any other expenses you might have had. Timeline between the LE and CD. If a client can't find or confirm clearance encumbrances, who usually is the best resource to guide the agent to help the client? Okay, so the best resource is you and your broker. Bottom line. Okay, but the timeline between the LE and the CD, the minimum timeline between LE and CD, right? It's not between LE and CD, it's between LE and closing is 7 business days. That's the minimum. So you're talking about 2 calendar weeks, right? Because between the CD, the LE is 3 business days plus the 7 business days is 10 total business days. We're talking about 2 total weeks to close. Now, if you can close in 2 weeks, a regular conventional transaction or FHA transaction or VA transaction, let me know how. Okay? Because like you said, need to clear encumbrances, need to do the inspections, need to do the appraisals, All that stuff needs to happen. Now, unfortunately, based on standards, I mean, not based on standards, based on what we are used to over here, let's say here in my area, at least in New Jersey, my area of New Jersey, we're used to 2 to 3 months at least, right? So an average deal could take 2 to 3 months. So I tell my clients already, look, we're going to put 2 months to close, but already expect that that might be a third month, right? So be ready for that. Why? Because of delays. What delays? Well, they have to clear title. That means they have to pay off the mortgage. If they don't pay off the mortgage, or if there's an issue with the payoff, it has to be corrected. It might take longer. There's something on title that we did not expect because the seller did not know that it needs to be corrected. We have to do appraisals. So by doing an appraisal, if it does not appraise, we are entitled to dispute the appraisal. So that might delay a little bit longer. We have to do inspections. If there's something wrong, we now go back to the negotiation table where we're looking for compensation at closing, right? It's not like we're going to reduce the price, but at closing, we're going to look for credits, for instance, right? So these contingencies have to go based on experience. So who's the best one to guide? Not the agent, but the client. The agent is the best one to guide the client. Now, who's responsible for guiding the agent? Considering the agent is you, the salesperson. Who's the best one to guide you? It's supposed to be your broker. You understand? So to answer this, long story short, your broker guides you and you guide your clients. Simple. Okay? So you're the one orchestrating the whole thing with all the moving pieces. You're the one playing checkers. You're the one bringing the appraisal, the title, the attorneys, the mortgage. You're bringing them all together, right? And making sure they do their parts. So I'm not saying you're the one that brings them to the table, but you can. But you are the one that guides everybody to the next section that's needed. Okay, because the mortgage company does not move until certain things are in place, like inspections. You're the one that has to tell your client to get an inspector, not the mortgage company. See what I'm saying? So you're the one that moves all the pieces for your clients. Okay? So timeline could vary. Minimum 2 weeks, right? Average 2 to 3 months. But there are cases where it takes 4, 5, even 6 months, depending on what the issues are. Next, is it safe to say that we can clear most debits and credits between the buyer and seller before closing to make things move easier? Well, actually, you have to do everything before closing. At the closing table, everything is settled already. We're just going to sign the paperwork and then disperse the payments. So you don't do this. All right? What you need to bring to clear this is the payoff statement from the mortgage company. You need to bring the taxes and any unpaid balances. You need to bring the water and any unpaid balances as a seller, right? So any credits that the seller promised, these are all along the way already. We don't get to the closing table without having these numbers. In fact, for you to get to the closing table, you need the CD. The CD is given to you, the closing disclosure is given to you at least 3 business days before closing. Okay? So yeah, this happens all before closing. Can we have all this information up front? Why not? There's still some things that are going to be pending, title company and attorneys and mortgage company. But can you have most of the information up front? Yeah. But then debits and credits. If there's an issue with the inspection, you find that there's mold. It takes $20,000 to fix the mold. You're going to ask the seller, hey, I need a credit of $20,000 at closing. You understand? So as much as you can get ready before closing, great. Right? Some things are settled even at closing. Last minute things like water bills sometimes. Right? So yeah, the idea is we don't go to closing until we have these settled. I think I just addressed it, like taxes, water bills, for instance, sewer bills. These are the things that we get last minute because it's the payoff. We need the last reading. So these are pretty much the things. Or surprises in terms of somebody, their credit is off, like it went down. So the mortgage company now charges an extra amount of money for points, for instance, to keep the rate low, and things happen right there and then. So there could be some surprises. The only thing you got to know ahead of time that has nothing to do with a third party where you would not have control. The only thing you have to know ahead of time is title and inspections and appraisal. Everything else comes from your agreement and these three things towards closing. So there's not much you as an agent can have towards closing, other than knowing that the buyer has the money for the closing table. Okay, those you got to have up front. Well, as many times as you want. That's all I can say. As many times as you want. You want to be here morning, evening, evening, morning, Monday, Friday, Tuesday, Wednesday. You choose whatever arrangement you want, whatever works for you. I'm just going to warn you that if you skip days, it's going to be a problem, right? But if you're doing this in a sequence, it's not impossible, but if you do this in a sequence, it's a lot easier, right? And if you're using, for instance, I had this one guy a couple of years ago, John. He what he did was he was on disability, right? And he took advantage. He took my morning class, my evening class, my Saturday class at the time. He took all of it in 3 months, which what was supposed to be 4 months, he did it in 3 months at the time. The courses were 3 days in the morning and 2 days at night, and then Saturdays. These are 3 different course settings. And he took as many as he could because he said, hey, at home, I cannot study. So I prefer to come to class to review everything all over again and listen to it as many times as I have to. I prefer to come to class in order to get this done. So again, you want to join both classes and you want to listen to things all over again as well, you can. Just know in the morning is one chapter, evening is another. Eventually your chapter will come up. You want to do it again? Sure, as many times as you want. Whatever works for you to pass, I'm here to help you with that. Okay? Now, it might cause some issues by showing up for so many classes, apparently. I don't know if that's what Zeline's talking about. Is that the legal reason? Well, yeah. So that will be a legal reason if there's nobody else to take over. There's 2 people, one dies. If the mortgage is no longer approved, then death is a legal reason to back out of a contract. But if it's a sale and the seller dies, the buyer's still entitled to buy. Understand? If it's a sale, the seller dies, the buyer's still entitled to buy. Transaction could go through because it was already pending. Again, these will be between attorneys to determine what's the next step and what's the family's wishes would be. Either or. Okay. For the buyer side is as long as they're qualified to buy, whoever survives. As long as they're qualified to buy, they can keep moving. If they're no longer qualified to buy because of the death of one person, then yes, could terminate the contract. For the seller, like I said, the buyer is still buying. That's not an issue, and then the money goes to the estate, so whoever the heirs are. But again, this part right here, when it comes to death, is between attorneys. If there's a question like this in the school or state exam, is usually regarding listings. If it's regarding listings and the seller dies, do you think we have an agreement? No. All right. If the realtor dies, the salesperson, do we have an agreement? We do, because the agreement was with the broker, not with the salesperson. So these are a few things to look at. The agreement is not with the salesperson, it's with the broker. We are agents of the broker. So if I sign a listing with a seller, I'm doing so on behalf of the broker. Okay? Great question, though. The same with, okay, the cooling off period thing? Yeah, same with leases. Yep. And I got your message. Yes. Okay, no problem. Writing Brendan. Any other questions, guys? Cheryl, do you have any questions? Don't forget, if I look this way, I'm talking to YouTube people. Cheryl, do you have any questions? You know why it's so weird? Because you guys see me in the same perspective, right? Because it's one camera. But then I see one is over here, then one's over here, then one's over here. So I have different people, right? And then the chats, I don't see the YouTube people. So sometimes it's that reaction. I look here and I think I'm talking to them, even though it's just text. Anyway. The weird thing. Virtual. All right, any other questions, guys? Ready to start? So, Mr. Joel, can you change your name, please? Showing as your email. Make sure you guys have your correct name there so it counts your hours. All right, so this way when I give you when I look at the final numbers to see if you're eligible to take the exam, you know, I don't have to be wondering, oh, it's the email, it's not the person. It gives me a totally different report. Because I search by person, not by email. You need some help, Joel? Done. You're taking too long to change your name. I did it. I'm gonna charge you extra, man. Hey, listen, that's not my fault. I'm gonna charge you extra. Here I am administrating your names and everything. All right, so we're gonna go do an overview of licensing and regulation. And the reason why this is an overview is because then we get into each state. Each state law is different, but this gives you a good idea of what licensing laws are before we get there. Now, virtually every real estate practitioner in the United States is subject to a license requirements according to laws of the state in which each practitioner resides and does business. States have enacted real estate license laws to ensure a minimal level of competence in real estate professionals, and state license laws also protect the public by requiring licensees to adhere to standards of ethical conduct and professionalism. A licensee who violates ethical and professional standards faces temporary or even permanent loss of their legal rights to practice real estate. The general thrust of the state's real estate license legislation is to establish personal, educational, and professional requirements for obtaining a license, to establish statutory guidelines of professional conduct and continuing education to maintain a license, to establish regulatory entity to administer and enforce licensing, to authorize a regulatory body to create regulations and procedures that will enable it to discharge its legal responsibilities. For all students of real estate who are planning to enter the field of practice, it is vitally important to understand state real estate license laws and their effect on one's envisioned career in real estate. Since real estate is large and complex industry, students must investigate local licensing requirements for specific activities. For example, it is likely that a state has special requirements for appraisers. On the other hand, a state may require no license for all those that work in corporate real estate. All 50 states have licensing requirements for practicing brokers and agents. Okay? Where the state license law and regulations conflict with federal laws, the state laws prevail. So, obtaining a real estate license. Obtaining a real estate license. Let's figure out, what do you need a license for? And we're going to repeat this once we get to the state portion. But what do you need a license for? Any person who performs a real estate license, real estate service on behalf of another party for consideration, meaning you're expecting some type of payment, must be duly licensed under state law. For example, a person who receives payment for helping a buyer locate a house must be licensed. However, an investor searching for a property to buy does not need a license because the investor is not acting on behalf of another party. So what you need to remember is, if you expect to get paid for helping somebody else, again, for another, if you expect to get paid, right, somehow, that's consideration, we're going to go over this in a second. But if you expect to get paid for providing a service to a third party, right, then you need a license. That's pretty much what it's saying. Okay? You need a license if you're helping somebody else. Now, somebody else and getting paid. Now, so consideration, though, is that exchange. That exchange could be money compensation, could be exchange of free services, and I'll explain that in a second, or any other valuable good or service that a person expects to be paid. So, money compensation. You're buying a $300,000 house, I want 6% of it, right? That's a money compensation. I'm going to help you buy a house, but you have to do certain things for me. Like you're a CPA, you're going to give me 10 years of free CPA service. One example, right? That means I'm exchanging a service. It's not for free, it's costing you your time, and time is money. You understand? Even though it says exchange of free services, right? I did my part, but now you're compensating for my work by giving me free service of whatever you do, right? So that is compensation. Any other valuable or good or service. For instance, if I'm helping my dad sell his house and he has a garage, and in the garage there's a car, right? And he says, son, sell my house and you get the car that's in the garage. The car is valuable good, right? It's a valuable good. It has value. Because it has value, it's compensation. Therefore, consideration. So if I'm getting some type or any type of compensation from a third party, even if it's a family member, it's a third party. You're getting any type of consideration, you must have a license. So the following services fall into the license required category. Brokering of sale, lease, or exchange transactions, managing property, including rental activities, appraising, counseling, syndication, and auctioning. Any of these generally, not always, generally fall into a license required category. Within these service areas, states may have more specific requirements or exemptions depending on the nature of the activity. For example, some states include business brokerage, and in the brokerage category, while other states do not. What is business brokerage? Before we move forward, is when you're helping somebody sell their restaurant, the business. When you're helping somebody sell their clothing store, the business. So you're brokering the sale of a business. Some states require a license where some do not. Similarly, some states allow certain forms of counseling while others do not. The point is to find out what kind of license, if any, your state requires for real estate activity you will be pursuing. Some people are exempt from this, and we're going to repeat all that in a couple of days. But some people are exempt from this. If you are the employee of a property owner, right, you're not being paid per transaction. You're an employee, you're being paid a salary, for instance. Right? So if you're an on-site rental agent in an apartment complex, you need a license. The answer is no. Okay? If you are a person that works, so you're a salaried employee of a managing company that's managing my properties, the managing company is not me. So it's a third party. So if you are a property manager or employee of a property management company, right, and you're working as a third party, so independent, you are getting paid for a service, right? If you work for me, the owner, directly, you're my employee, I'm the owner of the building, you're my employee, then you might not need a license, okay? Employees of transient lodging facilities, such as motels and hotels, they don't need licenses. Managers of residential condominiums and co-ops sometimes don't need licenses. Dealers in cemetery lots, always a tough one, but you might need a license or might not. Attorneys performing regular legal duties for a principal, they might be exempt. Regular legal duties. So if the judge says attorney, for instance, or somebody else other than attorney, but they're court appointed, the judge says, hey, Nadia, do me a favor. I'm appointing you. I'm the judge. I'm appointing you to help Tina sell the property, right? So you are responsible for doing so. But because it's court appointed, you're exempt from licensing laws. You got it? The moment the attorney or you start engaging in daily activities, like regular real estate activities instead of their legal activities, right, or duties, then they need a license. All right? You know, it's funny because in the morning I have Nidia and Nadia, and now in the evening I have Tina and I have Tiana. Guys, like, don't help me at all. At one point I had 2 Vanessas in class. You know, this is tough. Very tough. You guys just want to confuse me. All right, so licensing agencies, state licensing agencies, they issue 2 principal types of license. You have the broker's license and you have the salesperson license. Within these types are variations based on active or inactive status of the license and on the business identity and professional capacity of the licensee. So this is going to be very quick right here. Broker's license, you're either active or inactive. If you're inactive, obviously you're not producing, you're not doing anything, right? So you're inactive, but you don't lose your broker's license. You can reactivate it within a certain period. A broker's license could be held under a corporation. So if I am the broker of record as an individual, or if I'm the broker of record for a corporation like a Remax, Century 21, or even, let's say, New Direction Realty. An LLC, we can operate under an LLC. We can operate as a partnership. I can even be a non-resident broker. So my license is from New Jersey, but I want to open up a brokerage in Texas, right? I will be a non-resident broker in Texas. Salesperson, you're either an individual as a salesperson, active or inactive, or you could be a hybrid, which is a mix between broker and salesperson. And that is called broker salesperson. Okay, broker salesperson. Hey, Jen. Jen, by the way, I just see you joined. I don't know if you saw right before when I was closing the morning session. Right, sorry guys, it's just I have to address one thing. Right before I closed the morning session, I noticed that you had written something there, and I sent a question, and I left my number. So make sure you reach out to me with that question so I can explain to you. If you don't have my number, I'll give it to you again, okay? All right, so broker salesperson could be active or inactive. Now, broker's license. When we say broker by itself, when it says broker by itself, notice that there's broker salesperson, right? So there's broker and there's broker salesperson. When it says broker by itself, we are talking about broker of record. And when we say of record, it's the one that's responsible for the company. Okay? So broker of record is the one responsible for the company. Therefore, an active broker's license authorizes a licensee to represent clients by performing real estate services. Neither one of these, let me just jump back. Neither one of these allow you to represent the client. Neither one of these allow you to represent the client. Because who represents the client? Your broker. You are an agent of the broker. Okay? You're an agent of the broker. Therefore, we don't represent the client, we represent the broker that represents the client. So, if your license is expired, then you may not, or if it's inactive, you may not perform any brokerage activities. And the people that are under the broker cannot perform any activity if it expires or it's inactive. Okay? Sorry, what's the yes please? The yes please, you want the number again, or the yes please, you're going to ask me the question? Sorry, Jen just said that it's freezing on her. Go back inside, Jen. Go back inside. It's cold outside. Joel, yes, you are the helper of the broker, and you get compensated for being the helper. Now, the good thing is that usually most brokerages, they pay you very well to be the helper, meaning the majority of the compensation is yours to be the helper. Usually it's the other way around, right? The boss takes the most and the employee takes the least, right? In this case, it's the other way around. Okay? All right, next. Broker's licenses are typically valid for 1 or 2 year period, after which they must be renewed. Inactive status typically occurs at the option of a licensee who wants to leave the real estate business temporarily. A broker who's acting under the name of another under another name must register the name of the fictitious business entity. So like I said, if we're Remax, for instance, then I'm the broker, right? I need to register that I'm under Remax of Newark, for instance. That's the fictitious business entity. It's still an entity that I represent, that I'm responsible for. I need to register that. Okay? The most common brokerage. Okay, hold on. You want the number. This is going to be very expensive if I keep on repeating this. Actually, Shanice, since you're listening there, you can do the same thing you did in the morning. Do me a favor. Jen wants my number. Morning, Shanice said. Nobody understands your handwriting, so I'm going to type it. All right, so the most common brokerage identity is the sole proprietorship. Other business entities, however, may broker real estate. These include corporations, general partnerships, and limited partnerships. In order for these entities to perform real estate services, certain individuals within the organization generally must maintain an active broker's license. A broker who does business at locations other than the principal office requires a branch office license. So for every business that we open, or every location we open, we need to apply for a brand new license. It's not just, hey, I'm going to open up over here. No, we need to apply for it and pay for the licensing fees. All right, Jen, you ready? Denise, you made a mistake. Never call. Text. And if you text, WhatsApp. Okay? Or now it can be through the website. Okay? Some people start harassing me through the website. They don't even tell me who they are. They just like start asking, can I join the evening class? Right, Tiana? I'm like, I'm sorry, but I cannot see who you are for me to say yes or no. Like, if you're a student, yes. If not a student, then right? All right, so Jen, here you go. Number, no call, text, WhatsApp. Thank you. All right, so Ed, you wrote here how much is the fees? What fees? What fees are you talking about? What fees do you want to know? For renewal? Okay, so that depends on the state. We'll get to that when we get to the New Jersey portion for you. So, but it depends in each state. But we'll get there. All right. She just said yes. She didn't say I got it. She just said yes. So I'm not sure. All right. Right there. 908 418 8325. WhatsApp. Okay. Those text messages I have right now, and I'm sorry guys, I'm in serious need of somebody to answer my messages and my calls. But just text messages alone, I have almost 200 messages to reply. It's just text messages. WhatsApp right now I have 53 reply. But I'll get to it. Okay. That's why sometimes I say for you guys to insist to keep on sending messages, because then it bumps you up and I'll be able to see it and reply right away. Okay? So never feel afraid of sending more messages. Keep on insisting. All right. A broker's license authorizes a broker to perform services anywhere within the state's borders. This allows a broker to arrange the sale of an out-of-state property as long as the services are conducted within the state. It also allows a broker from one state. Okay, Jen, thank you. It also allows a broker from one state to co-broker a transaction with a broker from another state, provided that neither performs services in the other's state. So, what we're saying here is that I can have a New Jersey license, right? But I can do business in Texas. How can I do business in Texas? If I refer to them, I co-broker. So I'm going to find somebody in Texas to handle my client, and that's it. I'm out of the picture, right? But I don't need a Texas license. I can coordinate with somebody there to handle my client. Simple. Can we make money in other states? All day long. You have leads. If you know how to generate leads, sell those leads to the local realtors all day long. Referrals. That's right. Okay. A non-resident license empowers a broker to practice in another state. So if I want to have a presence in Texas versus just referring to Texas, then I can have a non-resident broker's license. Now, this type of license is commonly issued in areas where near state lines, where residents of two states are frequently principals in the transaction. So if you live right at the border of Pennsylvania and New Jersey, maybe it makes sense for you to have both licenses because you can jump in and out and service the local areas. I'm very close to New York, and to me, it doesn't make sense because it's totally different being at the border with PA or being at the border of New York, right? Border PA, when I cross, everything is still quiet. Traffic is not that hard. But border with New York, as soon as I get to downtown Manhattan, that's it. I lost my day right there. Just getting there, I lost my day. So imagine going to show houses and all that stuff and having to come back for another one. If I ever go to show a house in New York, I better block the whole day and make it early enough where I can still come back when there's daylight, as an example, right? So unless you live in certain areas, unless you live there or you spend a considerable time there, it doesn't make sense to have that license. And now you're going to say, well, in New York, the values are so high that it makes sense. Yes. Imagine doing a referral to somebody there and getting paid, let's say 25% for doing nothing. Even better, right? Because the 25% of doing nothing might be one sale here of doing a lot of work. So referrals all day long for me. Tina says, so when you refer to another state, do you get a referral pay? How is that decided? Whatever the price. So the industry average is 25%. Industry average. Can you ask for more? Sure, everything is negotiable. There's no standard. Can you say 35%? Sure. Do it. Again, 35% of what? Let me show you here real quick. There's two sides. There's a seller side, there's the buyer side, and that's the way we talk about things. Seller side, buyer side. There's two sides. So even when we do our presentations or interviews or whatever, we always talk about you doing transactions is per sides, not per volume. So if you do, if you represent the seller and you represent the buyer, then you represent two sides. Okay. So there's two sides. Let's say the commission was funny. Let's say the commission was 6%. That's the commission that the seller agreed to pay. That's a gross commission. And maybe they agreed to split, let's keep it even, 3%. 3%. As an example. So if you refer the seller, you get 25% of that. If you refer the buyer, you get 25% of that. Does that make sense? So you get 25%. Your referral commission is based on the side that you referred. So you referred somebody that wants to buy in the area. Whatever it's being offered to the buyer's agent, you get 25% of that. You have somebody that wants to sell, like they're your friend and they want to sell, and you find a realtor there. Hey, I have a seller for you. Boom, 25% of the seller side. That's it. If you find both, run to get that license. You get full commission. Right? You have a seller, you have a buyer. Now it makes sense. Anyway, so to address something right here. First this, and then I'll go to Tina. So I'll address Tiana, then I'll go to Tina. Okay? We got to make cuts somewhere, so I'll cut to Nate after. So Tiana, I can go to Florida with my license. The answer is, you can go anywhere you want with your license. It stays in your pocket or it'll be online, right? You can go anywhere you want with it. You can go to Florida with your New Jersey driver's license. Doesn't mean you're allowed to travel anywhere or do business there. What you can do in Florida is referrals. That means you cannot operate as a realtor. You cannot show houses for your buyer. You cannot attempt to list a property. You're not a resident of the state or have a non-resident license. All you can do is refer to somebody there. And New Jersey has no reciprocity with other states. So that means that, no, can't do anything other than refer. Got it? So can you go to Florida with your license? Yes, you can do business in Florida by referring to somebody that's locally licensed. Yeah. Denise, what do you mean? That's a lot. What's a lot over here? Was that the 30%, 35%? Is that's a lot? 25% is a lot. Okay. So if you ever refer anything to me, just letting you know, Denise, if you ever refer anything to me, I'm paying you 10%. Is that a deal? Let me know. Is that a deal or no? I'm going to refer a bunch of stuff to you. Really? Did you guys catch this? Let me see. That's a lot. What is a lot? 25%. To me, yes, it's a lot. So I say I pay you less. And now she wants 50-50. I should have gotten it in writing. Why should I get it in writing? So this never happens. You have to put it in writing. And look, it's your client. There's nothing that stops you from following up with your client. Nothing stops you following up with your client. It's not your client. I mean, it's your customer. It's not your client or customer for the particular transaction, but that was your lead. So can you follow up with them and say, hey, how did it go? Can you? Sure. Simple. Did you guys close? Oh, I'm not happy with this I'm not happy with Shanice. Yeah, because you want a 50-50. Let me get you somebody else. You know what I'm saying? It's a matter of negotiating. Ed, yes. There's a referral form. Every realty has a referral form. So let's say I refer to Kelly, to your wife, right? I refer to her right now to Elizabeth. She would have a referral form for me to sign, or my broker to sign as well. And then we put there the numbers as an example. Okay. All right. Salesperson we covered. Broker salesperson we covered. Voided license, as you guys may know, is something that expired, suspended, or was revoked. Therefore, you cannot perform any activities while it's voided. Okay. If your broker's license expires, is suspended or revoked, then all your licenses are likewise voided. So that means that if your broker's license goes bye-bye, you have to find another broker as soon as possible. All right, to obtain a real estate license, the applicant must fulfill certain requirements. While the license requirements vary from state to state, they commonly focus on personal background, education, real estate experience, and licensing examination. Personal requirements usually qualify a broker or salesperson like being of legal age and mentally competent, right? Being of sound mind. Some states might even require a high school diploma or equivalent. Moral character means that you know what's right and know what's wrong and going to be ethical about your profession. It starts here at the school, where instructors, we have to evaluate you guys and see if it's okay to even give you a certificate. Even if you pass, I can reject your certificate, right? So I have to have a reason of why I'm rejecting you. If I feel that you're going to be dangerous to this society as a realtor, right, that you will take advantage of people versus helping people, then I can cut you off. The second part of it is, once you apply for your license, you've done a background check. So you've done fingerprinting. If you don't present any criminal records, and if you fill out the questionnaire and nothing pops up contrary to what you're saying, right, then the state says you appear to be a decent person, decent enough to carry a license, right? Educational prerequisites. So every state has different laws of how many hours you have to do. So anywhere between 24 to 180 hours, right? State of New Jersey, 75. Some other states, 45. Some of them are 180 hours, like Texas is almost 108 hours, I think. So every state has different laws and different rules for the educational requirements, okay? For a broker's license, then they're going to ask for additional requirements. So we're going to get to that when we get to the state portion. For you to become a broker, you also have to have a certain amount of experience. In certain states, it could be at least 1 year or 4 years or whatever. So it varies of how many years you need in order to be eligible to become a broker. Okay. The next thing you need is agency affiliation, because again, we cannot deal directly with the client. We cannot deal directly with the seller, deal directly with the buyer. What does that mean? It means we cannot prepare a contract, agree to service, and collect monies directly from the client. An agency affiliation will force you to be part of a brokerage, and that broker is going to sponsor you, and all the activities that you'll have are on behalf of that broker. Okay, that's it. So when you go knock on doors and say, hey, Mr. Seller, do you want to sell? You're going there on behalf of New Direction Realty, for instance. You're going to go talk to buyers and say, buyer, do you want to buy? Well, you're going to go on behalf of, let's say, Century 21. So what you're doing is literally representing your flag, representing your brand, never in your name. Okay? So it's your team, it's not your name. Application. All aspects of application include background data. references, prior experience, fingerprinting, and fees to complete the application, and so on. You have to pass a state license examination, and then you have, every time you renew your license, you have to do continuous education. So if it's every year, depending on the state, every year you have to do CE credits. If it's every 2 years, then every 2 years prior to license, you have to do CE credits. Again, I'm just brushing right through because when we get to the actual state law, it's more in detail. License regulation, we have something called the Real Estate Commission or department or something to that effect, which will be focused on regulation, enforcement, right? Creation, enforcement, licensing, education, all that stuff. And if you screw up, they have bonds and recovery funds as well to protect the public. So what the Real Estate Commission does, it's that body of law, right, that oversees the licensing process, administers all aspects of the licensing laws, receives and deliberates on consumer complaints, and handles problems between licensees. Okay? The structure of the Real Estate Commission usually has a mix between somebody that represents the government, somebody that represents brokers, and somebody that represents the public, so general public, right? So there's different structures. They're appointed by the governor, right? And usually they have a renewable term. Now, the authority that they're given is regulatory, judicial, and administrative. So that means they create the rules, they enforce the rules, right? Administrative, and they can enforce the rules, and they can penalize you or make a judicial decision, administrative judicial decision on fines and penalties, okay? And verification and all that stuff. Next, regulatory powers enables the agency to pass specific regulations and rules to support the administration of licensed law. And judicial powers enabled to conduct hearings and investigations into activities of licensees and to rule on license suspensions and revocations, as I said already. And administrative powers to organization, staff organization, records, facilities, and so on. Education, we talked about it, license status, real estate schools, us, right? And right here. What are the regulated standards of practice and conduct? Regulated standards of practice and conduct. The second mission of the Real Estate Commission is to enact enforceable guidelines defining the ethical and professional behavior of licensees. These guidelines may include sanctions, so penalties, monetary penalties against fraud, including misrepresentation, concealment, collusion, violations of fiduciary duty, negligence, so you were careless, you did not do your work, you should have known better, failure to make the required disclosures, and I think you guys all know by now, disclose as much as you can, and you'll have barely any problems, right? Practicing law in completing and interpreting contracts, which a lot of realtors do and you cannot. We can help you fill in the blanks. We cannot give legal determination of what it means or it doesn't mean. So consult with your attorney to what this means, right? A lot of buyers and sellers are like, well, if you cannot explain this, then what kind of realtor are you? They don't understand, and realtors don't know how to explain that unfortunately these are standard forms. If you want to make a legal assumption or a legal determination about what it means, consult with your attorney. I cannot give you this type of advice. I'm not an attorney. You understand? So a lot of realtors, a lot of sellers and buyers don't understand this, and realtors don't know how to defend themselves in saying, I am not the lawyer. Okay, our job is to help you find houses and analyze the house and prepare the contract to the best of our ability, not to interpret contracts. Got it? So we always fall into that trap regardless. We always fall into the trap, but always make sure you put it out there. Say, hey, consult with your attorney on this, or I can make a reference to the attorney to discuss this with you. Right? That's the easiest way to do it. But never practice law. Mismanaging money. So if I give you money, a good faith deposit, and you go to Atlantic City with my money, right? You're going to go gamble with my money, right? I'm damn sure that I'm going to put a complaint against you, and I'm going to win. That's easy. And that you might get your license suspended. You might even get your license revoked. So don't play with other people's money, right? And if you guys go between this one and this one right here, for instance, if you guys go to these two, the escrow funds and kickbacks, and there's another one which is discrimination. It was going to be somewhere. Discrimination, for instance. These three are the main reasons why people get sanctioned. You can go to every real estate commission website, and you're going to see, you're going to look for enforcement, or you're going to look for sanctions, whatever they have in their site that because that's public records. So whatever they have there, you're going to look for that, and you're going to see the names of people, realtors and brokers, and it says exactly what they've done, what the penalty was, why did they lose their license, why are they suspended, why are they in probation. Everything is going to be there. And most of the times is mismanaging of funds for brokers. Sometimes for realtors if they received cash. Salespeople if they received cash. Kickbacks. There's a lot of these. Mortgage companies, title companies giving you money for you to do business with them. Right? That's the loyalty that we got. Because loyalty is no longer an agreement between gentlemen. Loyalty, and gentlewomen, loyalty is an agreement based on money. That's loyalty nowadays. I'll refer to you as long as you give me something, right? That's illegal, and you can get into a lot of trouble. Jen, are you going to talk about earnest money today? Not really. Not today. But if you have a specific question, I can address it. Okay? If you have a specific question, I can address it. Because today we're going to talk about, statutes, regulations, and so on, like licensing regulations, and then we're going to talk about risk management. This is one of the ways, by the way, to reduce your risk is not doing these things. It's called avoidance. Handling complaints against licensees. Real estate commissions must enforce license laws and regulations, and enforcement commonly takes the form of acting on complaints received from consumers and other licensees. And the real estate commission typically establishes a formal procedure to handle complaints and disputes in an orderly fashion. When a complaint comes into a commission, the complainant generally must file a formal complaint with all relevant circumstances of the dispute, and then the delegated official, whoever is going to be appointed, they will investigate and so on. If necessary, they issue an order for disciplinary action, which you can appeal. Every state has different rules. State of New Jersey, you have 10 days to appeal or for a hearing to appeal the ruling. Violation of any law or provision or regulation is punishable by suspension or revocation of the license. If the infraction is criminal, okay, then the commission may throw you to the actual proper judicial authority. At that point, real estate commission has nothing to do with you. Courts will handle you and then remand back to the commission the decision. So your license will either be suspended or fully revoked. Okay? And so on. Okay? Now, right here, the outcome of many cases of license law violation is negotiated financial settlement or court-ordered money judgment against the violator. So money judgment. If the licensee lacks financial resources, the settlement or judgment may be, to some extent, uncollectible. So if I don't have the money, I got sued for $1 million and I don't have the money to pay, right? Then if it's uncollectible, the states, right, to avoid the situation, the states may require the licensees to get a bond for the cost of a nominal fee. What some states do, instead of having a bond, right, they have a recovery fund right here instead of a bond. They have a recovery fund. That means we all give a fee to the states to set money aside in case we screw up. That's what it is. Okay. The problem is, if the fund pays something, if money comes out of the fund because of something you did, then your license will be suspended, or it's sometimes even completely revoked until you pay back all the amounts with interest. Okay. Again, these things will come up in the New Jersey portion or whatever state that you're going to be applying for. All right, before I go into closing this session, I have a question here that says, I got a question from the test. I want to know the difference between earnest money and escrow money, and who gets what, or is it added to the closing? Okay. So, let me go here because I have more space. You want to know the difference between earnest money and escrow money. So earnest money is good faith deposit, right? So earnest money deposit is the same as good faith deposit. When we start a transaction, we put an offer, we usually put a nominal fee. And let's say this nominal fee is $1,000. Okay? That's at the time of offer. Now, this money does not belong to the broker. So it must be deposited into an escrow account, or also called a trust account. Okay? Now, the money goes into the escrow account. Why? Because escrow means third party. So it's other people's money. It's not the broker's money. It's not the seller's money. It's the buyer's money if the deal goes through. If the deal does go through, then this money is taken from the escrow account and applied towards down payment. Okay? So if it went through, we're going to take the $1,000, apply it towards down payment. If it does not go through, then must be returned to the person that gave the good faith deposit. Okay? Sorry, letting the trucks go by. All right, so the difference between, so escrow account is one thing. You talked about earnest money, which is good faith deposit we put up front, right? The other question was, what's escrow money? So escrow money could be two different things. Escrow money could be the money that's held in escrow for down payments, for instance, with the good faith deposit. Escrow money could also be money for taxes and insurance. So it could be option number one, that down payment money, right, which we call, I'm sorry, let me actually put it here, the good faith deposit. Okay. It could be number two, money set aside for taxes and insurance. All right, and the reason we call it escrow money is because the bank is asking you at closing for you to have some money aside towards taxes and insurance. Or even with every payment that you make in principal and interest comes TI, taxes and insurance. So once they receive that payment, they take that portion, put it into a separate account that's called escrow money. So there are different variables to what escrow money means. Earnest money always means good faith deposit. The buyer saying, in good faith, I'm putting money here. Okay, in good faith, I'm putting money here towards this transaction. I'm showing you, seller, that I'm committed. That I'm not just putting $1,000 here, $1,000 there, $1,000 in every single house out there. That I'm really focused on yours, right? So the good faith is, if I don't pay, or if I don't go through with this, Mr. Seller or Mrs. Seller, you can keep the $1,000. If I don't go through with it, it was a good faith that I will follow through, that I really want your house. But if I don't, without a legal excuse, of course, if I back out with no reason, that money could be yours. That's what it is. Almost like a security deposit when it comes to a lease. Security deposit is the same thing, right? So a security deposit in a lease is you telling the landlord, hey, landlord, I'll occupy your unit. Thank you so much. I will not destroy your unit, nor will I miss any payments. Okay? Or any other conditions of the lease. I will not break them. But if I do, you can keep my security deposit. That's what it is. All right? So again, earnest money or good faith deposit, it's upfront with the offer saying, yes, I want this. You could win it if you follow through and get credited at closing towards down payment. Or you could lose it if you don't follow through and you get out with any reasonable, legal excuse. It goes to the seller. If the deal does not go through, then the money comes back to whoever gave the deposit. Simple. Okay. All right, Jen. Good. Glad you got it. Celine, you have a question mark here. Did you have a question? You do? All right. Okay. Here talking for half an hour. I thought you had. Okay, there you go. Let's see. Question. Regarding disclosures, do you have to disclose if anything bad happened inside the house? Like what? No, you don't have to type. I was going to say, like what? Like anything happened like a wall fell? Anything happened like, hey, there's a leak was found? If it's physical condition, the answer is yes. If it's a stigma condition, like somebody got killed or there was some other type of crime in there, no. We only have to present things that could affect the transaction. What can affect the transaction? The physical condition of the property. What could affect the transaction? The buyer doesn't have the money or doesn't get the mortgage, right? What could affect the transaction? The title cannot get cleared. These things affect the transaction, okay? What happened in the property, but it did not affect the physical condition of the property, also does not affect the value of the property, okay? So no, we don't have to disclose those things. All right, Nadia. When the escrow is put towards tax insurance after it's at a low balance, you keep adding the escrow. Okay, so usually what happens is there's an upfront escrow, right? We covered this in closings 2 days ago. There's the upfront escrow and there's the monthly escrow. The upfront escrow is at closing. They ask you for, let's say, 6 months of reserves for taxes and insurance. That means you have to give half of the year in taxes and reserves and insurance, and they put it aside. And then with every monthly payment, they charge principal, interest, taxes, and insurance. So is it possible that the balance will be low? Well, they're going to give you an annual escrow statement and let you know if they overpaid or overcharged, or undercharged. So they'll tell you, hey, last year taxes went up and we did not notice. Here's the numbers. This year you're going to pay an extra amount of dollars. So it shouldn't happen, but that's why they give you the annual statement. And if something is wrong, you can always dispute. And by the way, guys, always look at the annual statement, because sometimes you have insurance, but they put forced insurance, meaning your insurance company did not communicate with them. And then you're paying for two insurances, one that you know about and one you don't know about. Or you fail to renew the insurance for the house, right? And they placed their own insurance. Yours was $1,000, theirs $2,000. Because they don't shop around. They're like, hey, whatever, we're not paying it. They are. Okay? Pre-approved for what? For insurance? What? For the house. Hold on, is there a question that I missed? So escrow, hold on, the escrow is at closing. This escrow towards taxes and insurance is at closing. So you're already going to close, and then it's your monthly payment right there. So pre-approval, you're right, it's before anything. That should be your first step. Don't even look at houses if you don't have the money, right? It's the example I always give. When you go to a restaurant, before you go to the restaurant, find out how much money you have in your wallet. Simple. You don't show up at the restaurant, right? You ask for the food and then realize, I don't have money, or I don't have enough money, okay? So before you go, make sure you have the pre-approval, okay? Very, very important. Any other questions, guys? Consumers, questions? Consumers, questions? I think this is the most I've had questions in a while. Besides Mr. Badur in the beginning. Okay, very good. I like. All right, so guys, we're gonna go into a quick break. It is now 6:54. Hold on. Jen, are you going to talk about offers? It's not that chapter. I'm going into risk management, but if you have a specific question, as long as I got the time for it, I got no problem in explaining it. But it's not that chapter. We're going to go into risk management right after. I'm always welcome to answer questions. Okay, preferably related to the chapter, but we can swing a few things here and there. All right, guys. So 6:54. I'm gonna close this session on YouTube, guys. I'm gonna reopen it in a little bit. Make sure you're subscribed so you get notifications of when I come back online. Okay. Then I have a question, guys. Give me a second. Come on, YouTube, Jen. What's the question? Really? You're gonna type 2 words at a time? It's like, can someone? Oh, by the way, I'm always messing with people, okay? So don't feel bad. So the question is, can someone decline an offer? Absolutely. Why wouldn't you? Jen, will you marry me? Simple. I put an offer. You don't even know who I am. Can you decline the offer? Absolutely. You understand? You can always. I want to buy your house right now. You have to sell? No. Doesn't matter how many offers. Like you can have a bunch of offers and decline all of them. You don't have to accept any offer at all. You don't have to accept any offer at all. Remember that. Okay, guys? No offers have to be accepted. One of the things you have to remember is that you should reject offers. Like give notification, that's a matter of courtesy. Give notification to the other party that you are rejecting the offer. Okay, at a time. Okay. Okay. So you already have an offer approved and then another offer, a better offer comes in. That's what you're asking. And you get out of one offer and jump into the other because the other one's better. And the answer is, if it's within the cooling off period, it's within the 3 business days for the state of New Jersey or any other state, whatever the amount of time you have. If it's within that time, can you get out of the attorney review? Can you get out of the cooling off period and say, hey, no, I don't want to sell it to you anymore. I don't want to buy. I want you to buy from me anymore. Yes. Once it's under contract, then no. Okay. If I have an offer and it's beyond the 3 business days, for instance, in Jersey, it is binding. So I cannot back out of the deal because I have a better offer. So no. That's you preparing yourself to be sued. You guys got it? Got that cooling off period to say, nope. No, Tina. Once you accept the offer, that's it? No. That's why we have the right to attorney review. During the attorney review, all right? And we're going to go over that actually in a couple of days. We're going to talk about contracts in New Jersey, for example. But when you're in review periods, in the review period, you're not under contract. So can you cancel the offer? That's why we see a lot of times, guys, we see a lot of times back on the market, right? Sometimes it's because the deal fell through along the way, but a lot of times is you put an offer, and then we don't agree to the terms, whatever the changes are in the terms from attorney to attorney. We don't agree to the terms, and we just walk away. If it's within the 3 business days, I don't have to give you, and again, 3 business days, New Jersey as an example. But if it's within the 3 business days, I don't even have to give you a reason. I can just walk away. Like, I don't want it anymore. I changed my mind. If it's after that cooling off period, right? And when we say cooling off, is your mind is cooling off on the decision you emotionally made, right? So it's the time to be logical about things, right? So after that cooling off period, varies from state to state. After the cooling off period, then it's binding. It's legally binding. Again, I'm going to show you that in about two or three chapters, right? But it's legally binding. Have to abide by it. Okay. Jen says no one could answer that for me. Okay. I know that question. I know the question that you're asking in the state exam. And again, what I'm telling you, you cannot get out of one offer if the question states that it's still under the cooling off period or under the 3 business days or under attorney review. 3 terms are synonymous, right? If it's under that, within that time, can you back out? Sure. After that time, right? So if it says you're under contract, right? Or if it doesn't talk about attorney review or anything like that, then you're in a contract. If that's the case, then no, you cannot back out of a deal because you got a better offer. Yep. All right? If you do back out of a deal, so let's talk about this. If you do break a contract, then you have to compensate the person, right, that's getting out of the deal. So with that being said, the person can either sue you to force the closing because you had a binding contract. So they might sue you to force the sale. They might sue you for compensation, right? Or they might cancel the contract altogether and obligations, meaning that if that new contract doesn't go through, you can't come back to me either, right? So there's options for the buyer. For the seller, there's not many options. All right, guys? Good? Jen? Let me know. Ed said the most important is the absolute. Anybody else? Questions? All right. So if there's no questions, guys, we're going to go into that well-desired break. All right, it's 7:02. All right, cool. Jen says yes. Cheryl says yes. Great. So it's 7:02. We're going to go into break. We'll be back at 7:15. So you got 13 minutes. See you guys in a little bit. I will. So 7:15, Jen. But if you guys subscribe, you get the alerts. Okay, you get the alerts of me going back online. All right. I see you guys in a bit.